Welcome to the show. I am your host, Daniel. And I want to start out by saying, welcome to all the new subscribers to this channel this week. I don't believe how fast we have grown in just a week's time. So, welcome. Uh, Welcome to the channel. Welcome to my platform. I'm glad that you are supporting my channel that way. And just remember, any video content that I make, if I take notes about something and I make a video of it, it's going to be a while before it gets uploaded. Because I upload, the way I upload videos to the channel is every Monday, Wednesday, and Friday. And I do that to spread out content. So, it's not like I'm going to go every day. If I had a bunch of content like that, I would upload every day. I upload on Mondays, Wednesdays, and Fridays. So it spreads the content out that it's consistent, but it's not, it's not every day. That didn't make sense. Oh, well. There's something else I wanted to say, and I forgot what the hell I was going to say. Well, you know what? Let's just get started with Judge Perez, Alyssa Perez. Jesus, I'm tongue-tied today. I need another cup of coffee. So let's get started with Judge Alyssa Perez. I'll share my screen. Make it bigger. And here we go. And I will be watching and be interacting with the chat. Let me fix this.
This case is settled and we're here for a minor settlement hearing. Miss Marshall, Judge, I think we need to get Miss Marshall sworn in.
If you're calling her as a witness, absolutely. Miss Marshall, would you raise your right hand, please? Ma'am, do you swear or affirm any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You may proceed, Mr. Shull.
Miss Marshall, can you please state your full name for the record, including a middle name if you have one?
Ebony Catrice Marshall.
And you are the mother of the minor child, J.S., is that correct?
Correct.
When is J.S.'s birthday?
November the 6th, 2017.
And you're appearing today as the next friend for your child, correct?
Correct.
And you understand that means you're here to represent your child's best interest in this lawsuit?
Correct.
This lawsuit arises from an automobile accident that occurred on May 30th, 2021, where you and J.S. were traveling westbound on I-10 at or near 100 McRae Boulevard in El Paso County, Texas, correct?
Correct.
And defendant Lazo was traveling behind you, right?
Correct.
Subsequently, defendant Valdivizio was traveling behind defendant Lazo.
Correct.
Defendant Valdivizio failed to control his speed and impacted defendant Lazo, which caused her to impact your car, correct?
Correct.
And your child, J.S., suffered injuries due to this accident, true?
Correct.
What injuries did J.S. suffer?
He was having headaches.
Anything else besides headaches?
Negative, sir.
Now, J.S. received treatment for these headaches, correct?
Correct.
And how long did J.S. receive treatments for these headaches?
We just did one visit to the hospital.
Right. And what did they do for him at the or for J.S. at the hospital?
I can't quite remember. I think they just gave him some meds.
Now, you've reached a settlement with the defendants in this matter, correct?
Correct, sir.
And you've had the opportunity to discuss this proposed settlement with your attorneys, right?
Correct.
And you've had the opportunity to speak to the guardian ad litem, Miss Soraya Hanshu, who is with us today, correct?
Correct.
And Ms. Hanshu has explained this process and answered your questions?
Yes, sir.
Now, the settlement for JS is $6,750, correct?
Correct.
Now, you've reviewed your child's medical bills and records, correct?
Correct.
Now, there's a bill from Optum, which is one of the providers, for $2,027. And this was reduced by your attorneys to $1,000. You understand?
Yes, sir.
There's a bill from TRICARE for $685.70. And this was reduced to $300, right?
Yes, sir.
And your attorneys have their fee of $2,250, right?
Yes.
Now, this leaves your child $3,000 that goes to JS, correct?
Correct.
Now, this money is going to be deposited into the registry of the court. You will not have access to withdraw these funds. This money belongs to JS. Do you understand?
Yes.
And JS can come to the courthouse when JS turns 18 and can collect the money, right?
Right.
You understand that this matter could have gone to trial, right?
Correct.
Or could have been heard by this judge, by Judge Perez.
Correct.
And if you had gone to trial, you could have won more money, less money, the same amount of money, or no money at all, right?
Right.
You understand that by agreeing to this agreement, you and your child are hereby releasing the defendants from any and all claims in perpetuity. That means forever, right?
Correct.
Do you believe this settlement is fair and is reasonable for your child?
Yes, sir.
Do you believe this settlement is in your child's best interests?
Yes, sir.
And are you asking the court to approve this settlement on behalf of your child?
Yes, sir.
Your Honor, I have no further questions. I pass the witness.
Ms. Garcia, do you have any questions?
Your Honor, no, not at this time. Actually, I have one question, probably one or two. I just recalled, and I'll be quick, Your Honor.
Oh, go right ahead.
Ms. Marshall, good morning. My name is Jeanette Garcia, and I represent Ms. Lasso in this lawsuit that you filed. Do you understand who I am and who I represent?
I don't.
So I represent Ms. Lazo, who's one of the defendants.
Okay.
And so I just wanted to put on the record that you understand that you settled the total settlement for Ms. Lazo that we settled with the minor JS was a total of $3,000. Do you understand that?
Yes, ma'am.
And then your attorney broke down the process of everything that how it was going to go. So you understand that we're going to send over a release. And once you send over a release, you're signing away any and all future claims that could have been brought against Ms. Lasso in the future. Do you understand that?
Correct.
Okay, and thank you, Ms. Marshall. I don't have any further questions.
Thank you, Ms. Garcia. Mr. Flores, do you have any questions?
Yes, Your Honor. Good morning, ma'am. My name is Renee Flores, and I represent the defendant, Mr. Valdivieso. Do you understand who I am?
I don't.
Okay,
I don't.
all right. So there's two defendants on this case, and Ms. Garcia and I represent two different defendants. Okay.
Yes, sir.
Okay. So you understand that if the minor in this case requires more medical attention or has future medical expenses, my client, Mr. Valdivieso, is not going to be responsible for that, and that this is all the money you'll be receiving regarding this matter. You
Correct.
understand that?
Correct.
Okay. And having understanding that this is all the money that's going to be provided to y'all regarding this incident, are you asking that this court approve the settlement?
Yes, sir.
Okay. No further questions, Your Honor. Pass the witness.
Thank you. Ms. Hanshu?
Yes, I only have one question, Your Honor. Ms. Marshall, can you testify to the court that the minor no longer has any medical issues that you're concerned with regarding this accident?
Correct, ma'am.
So there's nothing further in terms of medical intervention and/or care that is required?
Negative.
Thank you so much.
Okay, anything else from Ms. Marshall? All right. Thank you, Ms. Marshall. Mr. Scholl, do you have anything else for the court?
I have nothing further, Your Honor.
Okay. Ms. Hanshu, I did receive your report. Well, actually, the report, the proposed order, I believe, had been signed on by everyone. Let me go back. The ad litem fees, how are we taking care of the ad litem fees? the proposed order says will be taxed against defendants Valdivieso and Lasso. Is that correct?
Yes, Your Honor.
Yes,
Yes.
okay, everybody's in agreement there. Then for, if there's nothing further, Ms. Henshaw, I'm just making sure, last call. Okay. If there's nothing further, then the court will make the determination that the settlement as proposed is in the best interest of the minor in this case, and I will approve the settlement, sign off on the documents provided, which included the judgment, let me see, and an order to invest, I think. The invoice, obviously the ad litem fees are approved as part of this settlement. And thank you, Ms. Hanshu, always for being so thorough in handling the ad litem cases. If there's nothing else, then we are adjourned. Ms. Marshall, I wish you and your son both continue to do well. Okay.
Thank you.
All right. Is there anything else?
I have nothing further, Judge.
Thank you very much for your time. I'll get
Thank
those.
you very much, Your Honor.
Have a good day.
Nothing further, Your Honor.
Thank you.
Thank you.
Take care. Okay, I think our next hearing isn't until 10, so I'm going to take a second and come back.
Yes, ma'am. Hello, Mr. Casada, are you there? Mr. Casada, Andrew Casada?
Yes, sir.
Hi, what's the last four of your cause number?
Give me 1 second. I'm pulling it up right now. It is 3903.
3903.
Yes, sir.
Okay, doc. And you're with representing Sedna or with Ms. Lavanati or?
I'm with Miss Serna. She was an attorney in our office. She's no
Okay.
longer at our office.
Okay, thank you, sir.
Yes, sir.
DC V0927.
Okay, perfect. Thank you, sir.
Yes, sir.
Mr. Nunez, if we're ready on anyone, let me know, okay?
Judge, we just got Ms. McLaughlin in, so already on page 2.
Let's go. All right, calling cause, Walter, you there? Yeah. Calling cause number 2025 DCV 0415, Kyle D. Jeglum versus Kristen Nicole Murillo et al. May I have announcements?
James Kennedy for the plaintiff.
Christina McLaughlin for defendant Murillo.
Good morning. Scheduling status conference. How are you doing? Do you want a trial date?
Trial date's fine. We've settled the case, I believe, with Ms. McLaughlin, recently tendered the policy limits. However, we have the case pending against Progressive, who's represented by Jose Vega or someone in his firm.
Oh, let's see. So we're missing someone.
Correct.
Oh, I don't see Mr. Vega. We're about 3 minutes early. Myrna, can you, we'll just keep talking here for a second and see if he shows up. What is our trial date on civil for new cases?
Judge, we're scheduling July and August and September. There's no special settings.
Mhm. Let me
It's
see.
July 24th,
Mhm.
August 14th, and September 25th.
Well, Mr. Kennedy, you're here, so do you have a preference?
I mean, let's just do the first date in July. In all honesty, I don't think Mr. Vega or anyone from his firm would really care. Most of the time we end up settling, honestly. And since there's a recent tender, the
Mm-hmm.
Progressive's will be the only live defendant. I know sometimes with liens, Ms. McLaughlin has to stick around till we finalize the other part. I don't know all those answers on that since it's a recent tender. So
Okay, so on that, I'm thinking we should be getting a non-suit from you all, so Ms. McLaughlin doesn't come back on this one, and then we'll set it for that July trial setting. I keep talking to see if somebody will pop in on Mr. Vega's behalf, but we'll use the July setting, and you all know the drill. You guys are
right.
so
And
good.
I've got another case anyhow, so I mean, maybe in that
Okay.
interim, we can explain it to him.
Sounds
And
good.
whomever, but I can't promise you she'll non-suit if there's a lien pending while the other one's settled. But
Understood.
will be settled and the release will be signed, but I don't know the dismissal issue because I don't really know what the lien issues are, honestly. Okay.
Understood. So,
Mr. Kennedy, on this one, the only lien possible is for the VA, and if there's no lien, then we just need the letter.
Okay. Yeah, well, I'll check on that. I just don't want to say something to the court and say, vote
Right.
you out, and then I can't.
got it.
But
We'll do
I'll
the July
not try to
trial
figure
date
out.
with the scheduling order, and then we'll see if Mr. Vega shows up.
That's perfect. And
Thank
if Mr. Vega doesn't, I'll reach out to him and call him.
Sounds good.
Your Honor, may I be excused?
Absolutely. Have a good day.
You too. Thank you.
Yeah, what are those AI meeting notes that happen, that pop in? I'm so not,
Some of the attorneys hire those systems and they follow them around to their scheduled hearings and pop in, but I just delete them, Judge.
yeah, I don't.
I'm not sure. Like, I know a lot of mediators and people like that have orders that say they don't allow it, just so you know.
Also, maybe we need to do, because it throws.
Yeah, I'd be careful just because, sometimes they're off and on the record conversations, and I don't know that recording. I don't think I'm allowed to, when I go into your courtroom, record things. I think there's a rule that prohibits that.
Right. And there's Mr. Morales from Mr. Vega. Mr. Morales, you're here on 0415, and you're right on time. But we were kind of talking about getting a trial date in July on that case.
Yes. So, as you know, I'm here for Mr. Vega, Your Honor.
Got it.
And I would agree with the July trial date as well.
Okay, so we'll get the scheduling order circulated, pick your mediator and all those wonderful things. If you need something outside those hearings, let us know via email with your file.
And just so you know, they recently tendered for Ms. McLaughlin on the 30,000. So will be the only live defendant for Progressive. Okay.
Okay.
Thank you so much. Okay, so now where are we heading, Mr. Nunez?
Judge, back to page 1.
Mm-hmm.
Calling cause number 2022 DCV 3599 Myrna Yolanda Quiñones et al. Versus Greenwood Motor Lines Inc. et al. Announcements, please.
Good morning, Your Honor. Omar Silva for the plaintiff. Ready?
Morning.
Good morning, Your Honor. Raymond Torres, I'm here for defendant R&L Carriers on behalf of Mr. Carlos Rincon. Mr. Rincon is currently logging on. If we could possibly have 5 minutes so that Mr. Rincon could make the argument, I would appreciate it, please.
Sure.
Okay.
That's fine. Is there anyone else ready? I hear a bunch of doorbells, so we got a bunch of folks.
Judge, I believe on page 3 on 2550, I believe we have Mr. Ray, Ms. Levin, someone from Ms. Lebanoni's office here for that one. Do you want me to call it, Judge?
Give me a second. And are we also waiting on someone from Mounts? I see a Monica Perez also there. You're talking about 2550, right?
Yes, ma'am.
So there's 3 attorneys, is that right?
Yes, ma'am. That's what I see.
Yeah. Okay.
Your Honor,
can I bring something up real quick?
Yes.
My case that I have, there's nobody that's going to appear on this one case because we settled it.
3686?
Yes.
I'm on it as well. I'm here, Your Honor.
I just
Oh, you
saw
are
it.
there? Okay.
I just saw it. So, we can call that one. So we don't have a pro se, is that right?
Right, there's two owners. That hasn't been resolved. We have to decide if we're gonna default, and we probably won't, honestly. But sorry, I didn't know if anybody was gonna appear for that one, so I apologize if he was here.
Okay, so I don't have a problem calling it, but Mr. Nunez, we're gonna make sure at 10:15 that there's nobody in the waiting room. I'm assuming that's Norma Bosques?
Sure.
Okay, so this is cause number 2024 DCB 3686. Sylvia Cifuentes Lopez versus Norma Bosques, Georgina Berba, and John Berba. May I have announcements, please?
James Kennedy for the plaintiff.
Renee Flores for defendant Norma Bosques.
Okay, so then the Berbas are the pro se defendants in this one?
Yes, Your Honor.
Didn't write the name down, but that sounds right, because there were two defendants listed.
By my docket, Norma Bosques is the pro se.
No, Your Honor.
All right. Okay, so Georgina Berba and John Berba are self-represented. Alrighty, we're set for a status conference. I have a notation here that we have some liens pending and Mr. Flores's clients have settled.
That's correct, Your Honor. There's two defendants that didn't file an answer. I've got to get with my client if they want to non-suit them or take a default. Typically, my preference would be just to non-suit and move on, but that will be after funding and dismissal of the other defendant. So,
how long before you anticipate that will happen? So I can set my next period.
if you give us 60 days for a reset, we should be good, unless there's some unusual issue, which typically we're got everything done by then.
Reset for 60 days. Is there anything else?
Your Honor, just that we did send off the checks on the 14th. Just want to make sure that Mr. Kennedy's office did receive them.
I have to ask, because if I say yes and I'm wrong, I mean,
I'm putting him on the spot, Your Honor.
But I mean, if we get the checks, just I'll verify and we can sign your dismissal. So I mean that you'll be out of that in that regard, and we'll just have to make a decision on the other two defendants. So.
Okay.
Okay.
I'll text you, Renee. I'll go ask right now.
I'm going to
sounds
reset
good.
it for a status in 60 days. Thank you, gentlemen. If you don't have anything else, you are excused.
Thank you, Your Honor. Do you need me to stick around? Oh yeah, we got Jose Vega, so I'm good. Okay.
All right. Thank you.
Thank you.
Okay. Hey, there's Mr. Rincon. We can go back.
Good morning, Your Honor.
Good morning. Page 1. Is that right, Mr. Nunez?
Yes, ma'am.
All right. Calling cause number 2022 DCB 3599 Myrna Yolanda Quinones et al. Versus Greenwood Motor Lines et al. May I have announcements, please?
Good morning, Your Honor. Omar Silva for the plaintiff. We're ready to proceed.
Your Honor, Carlos Rincon for the defendants.
Right. I have a set for both a final civil pretrial and a motion for continuance. I was reviewing the motion for continuance. Mr. Rincon, you want to tell me? I see we have a backup trial date. So we're specially set, is that right, in December? And then we have the backup trial date in February. So,
Your Honor, may it please the court, I am currently set priority setting in a very old case that I inherited in federal court in Albuquerque on December the 8th. And it's scheduled to be a 2-week trial. It's a 3-person fatality. In fact, it's with Mr. Lyles and Mr. White. You remember those two gentlemen?
I do.
So I expressed to Ms. Labinati that I need the case respectfully moved to the backup setting of February the 6th. Because I can't be at 2 places at once.
For purposes of the record, Ms. Labinati has also logged in now. Again, it's the motion for continuance. I think that was it, right, Mr. Rincon? In the motion, there wasn't anything else. I think there was some discussion about designating experts and having those depositions outstanding.
Yeah, we might need a couple of depositions, Your Honor, but basically, as I understand it, the case has been worked up for the most part.
Let me ask some logistical things. How long do you all anticipate this trial is going to take?
4 days, 5 days at the most.
Okay. All right, Mr. Silva or Ms. Labinati, who's
No,
handling?
I'm going to be the one arguing, Your Honor. Judge, this is, I don't know how many times this has been continued, but I understand that he loves to try cases with Lyles and not with me. So I feel a little bit bad about it, but he just tried a case with them and made them a lot of money. And, their clients apparently are taken care of and a lot of other attorneys in town. But with my office, I always get continuance from Mr. Rincon. So Judge, this is a very old case, was filed in 2022. The incident happened, in 2021. So it's not fair to my clients 4 years down the road and she still doesn't have a trial date. So last time, Judge, when we came to in front of the court even gave up a backup date because the court says if it can't go for any reason, we need a backup date. I had asked for a special setting in this case because of the, such an old case it is. And it honestly, Judge, I've tried over 100 jury trials and I know one thing, jurors always, for some reason, dilute clients' pain and suffering and clients' case by the length of the case, meaning it's like they roll their eyes every time you say it's been a 5, 6, 7, 8-year-old case. They just roll their eyes. And so I don't think it's fair to my client. And the reason that, because I have to try a case with the other attorneys, if the case it's not, this was scheduled before. So I think we just need to follow the rules. Which case was scheduled first, which case was older. That's all we need to do. We just need to follow the rules.
Your Honor, if I may, I believe the case I have in federal court in New Mexico is older. It flows from a 2021 accident.
So does this.
Yeah, and Your Honor, here's another thing. I don't know of another instance where I've ever approached this court for a trial continuance. I try cases like Ms. Lavinati, and by the way, I don't know what case she's referring to, but I don't even think there's been judgment entered in the previous matter that she alluded to, but that's another issue. I believe we've established good cause. We're not talking about an insurmountable delay. This is just a 2-month adjournment. You've already set a special setting, and I'd respectfully request that Your Honor grant my motion for continuance.
Your Honor, can we have a verification that the other case is going? Like, can we get, I don't.
You want to get Judge Gonzalez on the phone? It's going.
No, I know, but a lot of times cases settled last minute. So can we, you know what I mean? Like, can we just wait until when are you going to find out? When is it's in December. Cases settle all the time. And federal courts sometimes have criminal cases or sometimes they go with another case. Like, can we just wait as we get closer? I just feel like at least I'm entitled to that. We'll see what happens in that other case.
We've mediated the case. It's Hurtado versus F&F. We mediated it for 2 days in September. It didn't settle. We're not going to have a judicial settlement conference. I'm actually preparing my page line designations. They're due today. We're ready to proceed. The pretrial is set November 20th and 21st. And we start with jury selection the morning of December the 8th, and we're scheduled to go 2 weeks.
Ms. Hernandez, can you tell me when we set these 2 trial settings, the December and backup?
I'm checking to.
So if I understand, we are specially set to start on December 5th, and your New Mexico case is, I'm taking it to be specially set there on December 8th, right?
Yes, Your Honor.
And when was this scheduled? Carl, I'm sorry, I was in mediation with Carl Green and I had to jump here. Carlos, when was this case scheduled? It was filed March 2025. So it was scheduled March 2025.
The case was originally filed in state court in New Mexico and was removed, remanded, as I understand it, for several years. I don't know, as I sit here, when the case was actually set for trial. It may have been set for trial in the March, April timeframe.
Yeah, so
Well, I'm looking at it,
hold on.
March
Hold
31st.
on a second, Ms. Labinati. So Myrna, if you will confirm with me, I am looking at the order setting hearing that set the December and February backup dates in this case, and that was entered on February 7th, 2025.
Yes, Judge, that is a date.
So it sounds like it was set with the understanding and notice to the parties, to you all, prior to possibly your Mexico case. And it is specially set. So I don't know if subsequent to that, Mr. Rincon, because I don't want to get your cases confused, if the court had been given notice that you had a conflict, but my case appears to have been set first. And just because I've put a backup date there doesn't mean I'm going to use it. The special setting for December was intended for this case to go on that date, and that happened in February of this year. So we've had a good 8 months, maybe if I can count, maybe 7 months, where we know that this is the trial date. And so if you can tell me that your New Mexico case was set before mine, I'll take that into consideration. But at this point, I'm not inclined to grant the continuance. I'm going to reserve decision just for the moment. Let me double check something.
Your Honor, my federal case was definitely set for trial after your trial setting.
Yeah, so let me look at something else, just to be clear. Yeah. Okay. All right. For now, the motion for continuance is respectfully denied.
Okay, Your Honor.
Thank you very much.
Thank you very much.
you,
Can we be excused?
Yes, have a good day.
Thank you.
Everyone.
All right, who's next?
Judge, on page 3, top of the page, calling cause number 2024 DCV 3695, Janet Salazar et al. Versus PPSL Legacy at Cimarron et al. Announcements, please.
Good morning, Your Honor. Damian Rasmussen for plaintiff.
Michaela Dominguez for defendant.
Give me one second. Oh, yeah. All right, Mr. Rasmussen, I just muted you. There was a bunch of background noise. Okay, so we are
Sorry,
set
Judge, I'm downstairs.
for dismissal hearing. You all were to have conducted mediation. Do we have an outcome result?
So, Judge, we have a mediation scheduled for December 1st. That's the earliest we could get what the parties agree. So I think, can you just set a scheduling order and we can abide by all the court's rules and hopefully have that done by December 1st? But if not, we can go from there.
We are set for dismissal today because this case has not moved. That's what's going on.
Well, Judge, we've conducted depositions and it's moved. We're hoping it resolves in mediation, but we also need to have a scheduling order so we can abide by the court's order.
Did we never have a scheduling conference in this case? Scheduling status conference on June 4th. You did not appear, Mr. Rasmussen. Michaela Dominguez did. Motion to compel at scheduling conference on parties requested a status with the judge on July 9th. A motion to dismiss hearing on August 20th. A motion to compel that was reset from July on August 20th. Then a status, and then a motion to abate, stay, or a motion to compel arbitration on August 20th. Is that right?
That's right, Judge.
And so has any of that happened? So since July, you were asking for mediation, and now on eve of a dismissal hearing, it's set for December?
Judge, I think the defense is going to have to answer these questions. I've sent about 75 emails trying to schedule mediations with mediators that can go much sooner, and this is the one they wanted, and this was the earliest we could get it set.
Your Honor, from the defense's position, plaintiffs filed a motion to compel, and we filed the motion to compel arbitration. The parties talked about trying to reach an agreement with, before trial or before the case moved further. We agreed with plaintiff's counsel to continue those hearings if the court allowed to the date of this most recent status hearing. And then we decided again if we can get into mediation. We did get mediation set on December 1st. On my end, I have people who I have to confirm and get things to them before mediation can be set. So we did get it set December 1st with an arbitrator or the mediator who the parties agree with, and we both intend to work to get that settled at that time. But we agree with the status conference to keep us on track if the court allows.
So everybody just ignores that this was set for a dismissal? I mean, we keep talking about, so here's what's going to happen. Your original status conference was June 4th of this year, right? Scheduling status conference, right? So you're going to get a trial date in May of 2025. I'm sorry, 2026. Circulate the order, return it. We're going to meet again on December 3rd to check the status of your mediation.
Perfect. Thank you, Judge.
Thank you, Your Honor.
May we be excused?
Please, thank you. Who's next?
Judge, staying on page 3, calling cause number 2024 DCV 2550, Karina Calvo et al. Versus Jeffrey Hayes Rodriguez et al. Announcements, please.
Good morning, Your Honor. Omar Silva for the plaintiff. We ready to proceed?
Your Honor, Jimmy Ray on behalf of the defendant.
Are we still missing either Monica Bettis or someone subbing in for her?
Still missing, Judge.
Your Honor, I sent her an email a few minutes ago. We just recently, I guess this morning, finalized our settlement in this case.
Okay, so we'll do an entry of judgment in what, 60 days, 30 days?
If we could have 60 days, Judge, because the only issue that I've got in this one is we do have a minor, and I am not sure if my carrier will want a guardian ad litem and court approval or not. It's a relatively small amount, so it's possible we may not need a court approval.
We'll do
That is correct, Your Honor.
We'll do a 60-day status EOJ, and if you need an ad litem appointed, let us know sooner than later so we can get the ball rolling.
We'll make sure we have an answer on that this week, Judge.
Thank you, and we can remove it from the trial track. Thank you very much.
Thank you, Your Honor. May we be excused?
Yes.
Thank you.
What's next?
Judge, page 4. Is anyone here for GECU? GECU. And Judge, we'll skip that one.
No, we'll call it.
Yes, ma'am. Calling cause number 2025 DCV 0823 GECU versus Talita Carvajalo de Quino et al. Announcements, please.
Ms. Duran, if you're there, can you confirm that plaintiffs received notice of today's hearing?
Yes, Judge.
And anyone here on behalf of the defendants in 2025 DCV 0823?
Yes, Judge. They did receive notice and they did open it as well.
Thank you very much. We received, this is set for status dismissal back in September. If party failure to appear, the case is dismissed. Thank you. Who's next?
Judge, on page 4, calling cause number 2025 DCV 0771 Credit Acceptance Corporations versus Eugenio Estrada Jr. Announcements, please.
Good morning. Evisa Toro on behalf of the plaintiff, Credit Acceptance.
All right, anyone here on behalf of Eugenio Estrada Jr.? Have we had any contacts from this individual, Ms. Hernandez or Mr. Nunez?
No, ma'am.
All right, Ms. Sotelo, you may proceed on your default.
Thank you, Judge. So Mr. Estrada was served on June 14th, 2025. He did not file an answer when it was due. We did file the certificate of last known address, which was 261 Benson Drive, El Paso 79915. We did file also the statements with the bank with the account ending in 4338 pertaining to Mr. Estrada. We also have the affidavit of account showing the account was open March 27th, 2020. It was closed May 29, 2022. And there was a default balance of $9,192 with 50 cents. Along with that, we also filed the military declaration stating that he is not in the military. And being that he's not here today, Judge, we are asking for the default judgment on this case.
Okay, the court has reviewed your requests along with all the attachments. The court will take judicial notice of all the documents in the clerk's file, grant your request for judgment. I haven't gone through all my emails, Ms. Sotelo, so if you've sent the proposed order, I'm sure I'll get it. But if you haven't, please go ahead and send that for my signature, okay?
I did this morning and we'll wait for that. Thank you, Judge.
Thank you. Have a good day.
Thank you, likewise.
Who's next?
Judge, staying on page 4, calling cause number 2024 DCV 3622, Cesar Sanchez et al. Versus Blanca Orcasitas et al. Announcements, please.
Good morning, Your Honor. Ansel Escobar for the plaintiffs. And Mr. Leonel Nunez called me earlier and told me that he is in a bunch of federal hearings and he will not be here for another 15 minutes or so. I'm happy to give the court a status update without Mr. Nunez at the court's discretion.
And Judge, I'm going to be covering for Mr. Nunez. He is stuck in federal court, so I'm appearing on his behalf.
Well, that's a relief. Great. What's the update?
Your Honor, I've served initial disclosures. I am waiting on initial disclosures from defendants. I have served requests for productions and interrogatories and have sent some proposed mediators and mediation dates that fall after those discovery requests are due. Mr. Nunez called me earlier today, letting me know that he plans to get me responses to discovery and respond to my proposed mediation dates relatively soon.
Wait a minute, Mr. Escobar. The notation here and why I think when we scheduled it last time is that you all had a deadline of October 15th for mediation. That's why you're set today, right?
Yes, Your Honor, that's correct. We did not meet that deadline. I had not received any initial disclosures or responses from Mr. Nunez relative to getting mediation set up. I have.
Ms. Yage, why am I having more delays?
Judge, I do not know why exactly, but Mr. Nunez did tell me that he had gathered documents from his clients and that he was going to be submitting them to Mr. Escobar. And that is the extent of the written discovery that he informed me of.
Okay, so deadlines don't mean anything, right?
That's certainly not the intent of the plaintiffs. We've tried to meet those deadlines, Your Honor, and apologize for being unable to.
Mr. Yage, this is becoming an ongoing issue with Mr. Nunez. Ongoing issue. So I expect him to be present at the final civil pretrial conference, which is usually the deadline by which people are supposed to mediate. So luckily, I don't get to see you till then unless you ask for a hearing. But if that deadline is not reached when, I'm hearing there's at least some effort being, at least from Mr. Escobar, to have that done, we're going to have a problem because Mr. Nunez keeps either not appearing or not complying with requests or deadlines. So see you on February 11th.
Yes, Your Honor. And is that hearing going to be in person or is it conducted by Zoom as well?
On Zoom.
Thank you, Your Honor. I will let him know.
Thank you very much.
May we be
excused? Have a nice day.
Or if you all need anything before then, please schedule your hearing with the court and appear. Thank you very much. Who's next?
Judge, top of page 5, calling cause number 2023 DCV 3903, Elizabeth Quintana et al. Versus Pantusa Towing et al. Announcements, please.
Good morning, Judge. This is Andrew Casado with Rosenblatt Law Firm for the movements on this motion to withdraw.
Joshua Biganowski on behalf of the plaintiff, John Gardner.
Jeff McElroy on behalf of intervener plaintiff Belinda Luke.
Charles Ruman on behalf of intervener plaintiff Omar Ronquillo.
Your Honor, Mike McLean, I'll ultimately, I think, be substituting for Mr. Antonio Zubia after the withdrawal is granted.
Carolyn Ronhell on behalf of defendant Pantusa Towing DFW.
Okay. We are set on the motion to withdraw. Bear with me. So I'm sorry, Mr. McLean. Oh, okay, who is the movement on the motion to withdraw?
I am, Judge.
Okay, Mr. Quesada, let me hear it.
Judge, so we're moving to withdraw. We've been unable to communicate effectively with our clients, and there's a number of them. So bear with me as I read through this. Pantusa Towing and Recovery LLC, Towing Headquarters LLC, Pantusa Capital Ventures LLC, Hello Reviews LLC, Trucking Leads LLC, Pantusa Towing El Paso LLC, Vandalay Industrial Investments LLC, Pantusa Towing Atlanta LLC, and Antonio Zubia, who Mr. McLean has indicated he will be substituting for. We've reached out to the other attorneys for the interveners and the plaintiffs and the other defendants on this matter. We've obtained a couple signatures on our proposed order to withdraw from us, but we have not heard from everybody, and we have not heard back from Mr. Pantusa himself. Mr. Zubia has given us permission to sign the order on his behalf on the motion to withdraw, but Mr. Pantusa has not responded.
What was were they aware of this hearing and how to log on, all of those things? Do we have some kind of separate notice?
Yes, Judge, we sent out the fiat via email to all of the parties, and including Mr. Pantusa. We had been responding with him, or he had been communicating with him regularly via email. And he stopped responding to us at some point, I believe in August. We've been unable to reach him.
So what's going on? I mean, why is that? Do you know?
I do not, Judge. There had been recently a change in our personnel in our office. Elena Cerna was handling our case, or handling this case from our office. She's recently left the firm, so I don't know if he just doesn't want to work with us, or if he's planning to retain her. I'm not sure, Judge. Since she's left, we have not had effective communications with him. He's behind on his bills with our office, and so for those reasons, we're seeking to withdraw from this case.
Okay. All right. On this case, we are set. We're set until November of next year. The request to withdraw is granted.
Thank you, Judge.
All right. That's technically the only thing we were set for today. And wow, we don't have a final status conference until September. Is there anything from any of the other parties?
Yes, Your Honor, just as a formality, I believe, can we go ahead and have Mr. McLean enter an appearance for Mr. Zubia now that withdrawal has been permitted for Mr. Quesada?
Sure, you can file it if you haven't already, Mr. McLean.
Your Honor, I actually filed a motion to consolidate.
I saw that.
Yeah. There was a subrogation matter in the 205th that I already answered for Mr. Zubia. There's also another State Farm subrogation matter against him and Pantusa that are in your court. So I'll file a motion to consolidate that one as well. And then I guess I'll file an entry of appearance just for formality's sake as well.
This
I don't know if those would,
timetable, yeah, that'll work, but this timetable is like, that's a lot of dead time for me. I probably feel like I want to bring you all in on a status conference in about 60 days if you all don't have something filed and are requesting hearings on sooner.
well, and also not to to dash any hopes, I'm not defending this under any insurance policy. Plaintiff's counsel, Mr. Zubia, doesn't have any other insurance.
Okay. So we're gonna add, Myrna, we're gonna add a status conference, I'm thinking in January. And then if there are any pleadings either already filed or filed in the interim, please, if you need a hearing, request your hearing and we'll get you set, okay?
Yes, ma'am.
All righty.
Thank you, Your Honor. May we be excused?
Hey, we'll see you next time.
Thank you, Your Honor.
Have a good day. Who's next?
Judge, page 5, calling cause number 2025 DCV 2036, Angeline Maicala Harpoon versus Transportadora Norte de Chihuahua SATCV et al. Announcements, please.
Good morning, Judge. Nathan Villarreal here for the plaintiff, Ms. Harpoon.
And Your Honor, this is Andres Almanzan on behalf of the defendant, Transportadora Norte de Chihuahua.
Good morning. We are set for a scheduling status conference. You ready for maybe what, an August trial date, or were you looking for something else?
Plaintiff has no objection to August 2026 trial date. I know that there is another defendant who has not answered yet. The return of service was filed with this court on October 13th, and the defendant was served through the Texas Transportation Commission, and that date of service is October 6th. So I think we're still...
Oh, we're early? You want to come back in 30 days for a scheduling status conference?
Yes, Judge. I'm looking at the service. We are going to be filing a special appearance. We believe there is a defect that does need to be raised with respect to the Hague Service Convention.
Okay.
We should have the special appearance on file by Monday. So that will be raised. Obviously, plaintiff's counsel can review the special appearance. We might need to have a hearing on the special appearance. So I do believe that it is probably more appropriate to have a status first, if not a hearing on the special appearance, so we can iron out whether the special appearance, needs to be heard, or whether at some point the truck driver co-defendant will be appearing before the court before we have a scheduling order and a trial date, Your Honor.
Okay, so we have some things that are kind of quickly pending, I guess. I'm going to reset this for the 26th of November. I'm pretty sure that's not Thanksgiving.
Judge, I've got a vacation certificate. Can we get a date in December instead of November, if that's okay?
We can do the 3rd. And anything that, you all are mentioning today, if you're going to have something filed quickly, you can anticipate utilizing that date as well for your hearing. Just let Ms. Hernandez know. For my purposes right now, we're resetting this for December.
Okay. I'm available, Your Honor. Yes, ma'am. December 3rd. Yes, ma'am.
And if you file anything, Mr. Almanzan, same for you, Mr. Villarreal, here in the next, week or so, still make your hearing request, but we could probably still use that date.
Okay. We appreciate it, Judge. Thank you.
very much.
Appreciate it.
Okay.
Thank you, Judge.
Thank you.
May we be excused?
Let's have a good day.
Okay, thank you. Bye-bye.
Who's next?
Judge, page 6, calling cause number 2025 DCV 0829, Maria Chavez versus Walmart Stores Texas LLC et al. Announcements, please.
Good morning, Your Honor. Omar Silva for plaintiff. Ready?
Good morning, Your Honor. Lolita Lamantes for defendant Walmart.
All right, we were set for a scheduling status conference. Same. I'm thinking if you all need a trial day, we'll look at August 2026.
That works.
Yes, Your Honor, that works.
Okay, so we'll get you the scheduling order. What's the actual date on the August trial setting, Myrna?
Judge, it's August 14th.
14th, that's what I thought. Okay, so August 14, 2026, get the scheduling order together, return it to the court. You'll have your settings, pick your mediator, put it on the order. Anything outside of those settings, please request your hearing with your filed pleading with Ms. Hernandez, okay?
Thank you, Your Honor.
Thank you
Thank
very
you.
much. If you don't have anything else, you're good to go.
Thank you.
Thank you, Your Honor.
Who's next?
Judge, page 6, calling cause number 2025 DCV 0974, Elizabeth Quintana et al. Versus Nicole Mayers. Announcements, please.
Good morning, Your Honor. Lainey Piercy for the plaintiff.
Oh, this is strange. Anyone here on behalf of Nicole Mares? So wait a minute, Miss Piercy, let me see. I'm looking at events here. We had a friendly suit back in July?
Yes, and we finally got the check, and part of it needs to be invested into the registry of the court. And so we filed a motion to invest those funds, and we were waiting to hear back from the guardian ad litem and the defense counsel on their position on the order. We finally heard back this morning from the guardian ad litem, but we haven't heard from the defendant. I was hoping that we could just submit that order and you would sign off on it, since it was basically signed off on in the friendly suit.
So I know they've had some changes in counsel right on the other side. So I see the motion to invest funds was filed about a week ago.
That's right.
Oh, for my purposes, I am going to reset you for 2 weeks status, anticipating what you're saying. In other words, that everybody will have it by agreement. And if you forward it to the court, I'll sign off on it and then we can cancel that hearing, but I'll follow up in 2 weeks, okay?
Okay, that's fine, Judge. Thank you so
very
much. I will continue to try to get in to touch with them. I've asked them
Yeah.
several times in the past week, but I haven't heard back. So
I'm looking at the notice of firm change.
yeah, and I did send it to the correct
Okay.
email.
New person?
So,
Okay.
yes.
Okay, thank you very much. You're excused.
Thank you.
Who's next?
Judge, we don't have one appearing for the next one. It's
Call it.
cause number 2025 DCV 0821, Credit Acceptance Corporation versus Gabriela Moreno. Announcements, please.
No one in the waiting room, Mr. Nunez?
No, ma'am.
Okay, so I don't have anyone here on behalf of plaintiff or defense. Ms. Duran, can you check to see if plaintiffs received and possibly open notice?
They did receive notice and they did open it September 8th, 2025, Judge.
So for failure to appear, that cause is dismissed. Mr. Long is here on what?
On page 7, Judge, on 0927, top of the page, but we don't have anyone from Mr. Spencer.
Okay.
Your Honor.
Thank you for waiting. We'll see if as soon as we knock out a few of these, we can.
I understand. No problem. Thank you, Judge.
So the next one, we're at 10:30 already, is 2025 DCV 0853 LVNB Funding LLC versus Luis Sanchez. May I have announcements?
Judge, that one was canceled earlier. Myrna advised me.
It has
Cancel
an order of non-suit, Judge.
non-suit, ándale pues. Okay. And then we have our 11 o'clock. So we need Mr. Spencer. And if we can get Mr. Mundell and opposing counsel there. We also have a motion to dismiss. So everything is not until 11 at this point. All right, we can take a break.
Yes, ma'am. Oh, Mr. Anda, it'll be just a little bit.
status conference, Mr. Spencer, give me an update, please.
Yes, ma'am. Judge, we were able to officially serve Ojos Locos, Sports Cantina, and Oil Texas Restaurants represented by Mr. Long. We've exchanged initial disclosures. Some interrogatories and production was provided to me, and we've responded accordingly. I am having trouble, and I will probably be filing a motion with the court to serve Texas United Security Services. We have a couple affidavits from our process server that need to be finalized, but the register agent I'm pretty confident is avoiding service. The mom allegedly is not having communication with her son. So we're having trouble with that. And for the other party, Jeffrey Evareste, we have not been able to locate him. But that, in a nutshell, Your Honor, is the status of what's going on.
So this is our first status scheduling conference. So, we're missing at least one. I'm happy to reset this for 30 days. I was going to say 60, but if we do 60, that's going to put us at the end of 2026, and I really don't want to do that. So we're going to reset for 30 days unless Mr. Long, I know that's kind of a anticlimactic result to waiting here for 2 hours, but it looks like we.
Your Honor, I have no expectations. It's my fault. I was very early. I got to hear how you handled things, so I was preparing myself what I would say.
Today wasn't a good day. I was grumpy, so no.
No, look, I love it. I don't tend to not follow rules and court orders, so I don't anticipate I'll be on your wrong side anytime soon. So hopefully not.
We are on the record, right, Mr. Chiriboga? We're just going to make sure that
sign my name to it.
You all in 30 days.
Okay, Your Honor, we'll receive a separate notice for that.
You will. And at that point, I feel more comfortable setting a trial date that won't put us too far back. Even if we're at the end of next year, that's still consistent with my usual timetable. Okay.
Understood.
Have a good day and thank you for your time.
Thank you, Your Honor. Good to see you,
That
Jake.
sounds good, Your Honor. Thank you, Your Honor.
Take care.
10:59. So do we know where Mr. Mandel is?
I called his office, Judge, and told him he had the 11 o'clock, and they said they were sending him a message.
Oh, okay. Okay. So I'm going to talk really slow. Have we had anyone? Where is she? Where is the name? Rosemary Weaver. Not yet. Okay.
Mr. Mandel's here.
Mr. Mandel. Handle this one very quickly. Good morning, Mr. Mandel. You there? Got it. All right. Calling cause number 2025 DCV 0994, Patricia Salazar versus Jamie Storer. May I have announcement?
Good morning, Judge. Cal Mandel for plaintiff.
Good morning. It's Kara Neal for defendant Storer.
Good morning. Scheduling status conference. How are you all doing? You ready for a trial date?
Judge, I think so. If it's not too close, we're working our way through written discovery. We need to take a couple depots in this case and maybe get it mediated. But I think it would be good if we had a trial setting maybe next summer or a few months after that, and it'll give
I've
us
got August 14th. What do you all think of that date?
Judge, that's the most perfect date.
Sounds good.
It's my day, Mr. Mandel. I never get told that. Hello. Now, Miss Neal, you won't hurt my feelings if you tell me it's not perfect.
You said August 14th?
I think so. 2026.
I got that as a Friday. Do we want to do a Monday or?
So we pick juries on Fridays. Docket will be on the Wednesday, and then we begin evidence on Monday.
Gotcha. It works for me. I just wanted to make sure.
It is perfect. Let's run away, fill out your order, return it to the court before something becomes not perfect. And thank you,
Thank you,
for your
Judge.
time.
Appreciate you. Have a good day.
You too. Take care.
Thank
All
you.
right.
Bye-bye.
Now we're on perfect timing now for our motion. Is this it's a motion to dismiss. I thought it was the motion to withdraw. Oh, is that right? We're set for
So, Your Honor, we were here a month ago on opposing counsel's motion to withdraw. They represent the plaintiff, and you had asked them to amend and add the last known address for the plaintiff, which they did amend. And then you said that if we didn't hear from the plaintiff in 30 days, you would dismiss. And no one's been able to get in contact with her. Does that match your recollection, Mr. Aranda?
Yes, Judge. I did file my amended motion with the information requested by the court.
Can I call it first? Please. Because yes,
Absolutely.
I want to take care of it. 2025 DCV 0927, wait. 2025 DCV 1391, Rosemary Weaver versus Trevor Williams. May I have announcements, please?
Marco Aranda for plaintiff, Miss Rosemary Weaver.
Christy Needler for defendant, defendant River Oaks.
Oh, correct. Okay, and I just want to be clear, Mr. Hernandez, we've had no contacts from Rosemary Weaver. Is that right?
No,
That's
ma'am.
right, Judge.
And I do recall we had the motion to withdraw outstanding from our last hearing, and there were just some kind of final details the court was looking to confirm. It does appear that the September 12th order setting hearing for today on the motion to withdraw and the motion to dismiss Ms. Hernandez, that was mailed to Ms. Weaver at her last known address. Is that right?
Yes, ma'am.
And it looks like it was also emailed to her.
I need to verify that, Judge.
Okay.
I can confirm, Judge. She was served. She just did not open it.
I shouldn't open it. Okay. Okay. All right. So, Mr. Nunez, I'm not sure I heard from you. We haven't heard from Ms. Weaver. Is that right?
That's right, Judge.
Okay. And it's 11:03. Hearing was at 11. The motion to withdraw, I did review the motion to withdraw and it included the additional details. So thank you, Mr. Aranda. Your request is granted. In terms of, I have this down for a motion to dismiss, but I don't recall that it was an explicit motion by you, Ms. Needler, or it was the court's.
It was yours, Your Honor. You said that if you were going to reset it, and if we hadn't heard from her by then, you would dismiss the case.
So to be clear, it's not a motion to dismiss. It is a dismissal hearing that was set at the same time as the motion to withdraw.
Yes, Your Honor.
Weaver not having appeared today, after having received notice the case is going to be dismissed for want of prosecution and her failure to appear.
Thank you, Your Honor.
Thank you very much. Thank you, guys. Y'all are good to go.
Thank you, Judge. May I be excused, Your Honor?
She went to the beach, huh? She took off to the beach.
Yeah, I do the same thing.
I went too. What am I doing here? Hi, Mr. Aranda.
Good to see you guys. Thank you, Judge.
And so we have a friendly suit at 11:15, right?
Yes, ma'am. Mr. La Rosa and the defendant are here.
I don't know what time. Like I saw it on Odyssey, but it's not on my doc. I mean, I must have run out of paper or something on my docket. So whenever everyone is here for the friendly suit, we can get started. Are we going to be missing? Who's going to be standing in for Mr. White?
Good morning, Your Honor.
Morning.
I believe, is it at 11:15? I'm sorry, am I late?
No, you're. It's
okay.
Minutes. But let me double check. Did we receive Angie's report, Brenda? Let me double check.
Let me check on that, Judge.
Mm-hmm.
I don't think so.
I feel like we didn't either, but I could be wrong. I don't see anything in my email. Was the friendly suit ready to go, Ms. Zaragoza?
From my end, it was, and then this morning we all approved the judgment. I know Ms. Carrion Beltran, she had everything on our end. I emailed her, didn't get a response, but you know.
Was today, had we already had a full hearing?
No, ma'am.
Okay. So we're still pending. It says we had this set for September 17th. Right. We might have had some. And Ms. Calderon is here to testify right now. So yeah. I'm not sure where the other attorneys. Oh, the ad litem report was filed since July.
Mm-hmm. Yeah, I believe so Mr. White, I think, was in a transition.
There's
from
Mr.
firms.
Grambling. Maybe Mr. Grambling's here for that.
Yeah.
I've just sent you something, Judge. It was on the email this morning.
Okay.
Good morning, Your Honor.
Good morning. Are you here on this friendly suit, Mr.
I
Brown?
am, Your Honor.
Oh, okay. Okay, let me go through a few of these. Okay, I just got that email. Okay, I have a proposed judgment, but it doesn't have the party signatures. And doesn't have the party signatures. And let me go back to the report.
Your Honor, can we submit one with people's names with permission? In other words, if I sign it and then I put Stephanie and everybody else's with permission on it, is that okay?
That's fine by me. That's fine by me. But do we know if Miss Carrion Beltran is going to be here?
I don't know.
Technically, we're still early.
Correct.
But if somebody made a call, Mr. Nanez, then maybe we could get her here.
Yes, ma'am.
Yeah. As soon as everyone's here, we'll get started and we'll bring in Miss Calderon.
I'm just going to ask Stephanie a question. Stephanie, can I sign your name with permission on the judgment?
You may. Thank you.
Thank you.
Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court criminal docket for October 14, 2025. All matters being heard today are being heard in accordance. Oh, let me make sure. Is Walter there? All right. In accordance with all directives regarding remote proceedings, in addition to that, we are streaming all matters live via YouTube for public viewing. I believe you said this is Mr. Rollins, Mr. Nanez?
Yes, ma'am.
Okay.
On page 14.
Calling cause numbers 2020-0D01714 and 2020-0D02293, each case style the state of Texas versus Randy Rollins. May I have announcements, please?
Ivan Martinez for the state.
Samantha Ragg on behalf of Jeff Ragg over ready, Your Honor.
For purposes of the record, Mr. Rollins is appearing remotely from the jail annex. I showed in the case summary that we had discussed last time, modification to safety, or you could do 12 months on the state jail felony.
Yes, Your Honor. As of yesterday, Mr. Rollins, he wanted the 12 months on the revocation.
No, Your Honor, that's incorrect.
Okay, so what we are here for are probation status hearings.
Right.
What we can do, I don't know if we've had the opportunity to fully discuss.
I did, Your Honor. I did. I was supposed to inquire, if I may speak. Okay,
Ms. Rago? Okay. So let me just tell you, and I'll let Ms. Rago speak right now in just a second. Just understand, sir, that do not disclose to the court. The prosecutor is here, the state is here. Please do not say anything that might hurt your cases. Your cases, in terms of the probation cases, I don't recall, he didn't have a new arrest, right, Ms. Rago?
Correct, Your Honor.
Okay. And then again, Ms. Rago, I don't know if you have any input or want to advise Mr. Rollins of anything.
Mr. Rollins, the prosecutor is here, so just be aware of that. I would recommend not speaking. We can go out to the annex and see you again if you change your mind, and we can report back to the court.
That's okay. I'd rather speak. I inquired to the court. I didn't know percent of time I would be doing state jail. So, and I've heard it's day per day here. So I don't want to discard treatment. I would rather go to safety.
Okay, so you're asking for treatment. I apologize, Mr. Rollins. It cuts off just a little bit, but I think I heard the gist of what you were saying is you were opting for treatment. Is that correct?
Yes, ma'am.
Okay. Ms. Rago, for my purposes, because I think we have been here within the past few weeks, I'm happy to accept that and get modifications going. So you need to let me know if there is a change of plan, okay?
Yeah. Yes, Your Honor.
Really soon, because I know probation will get me those modifications. Mr. Rollins, you've discussed with your attorney all the details of what this treatment means. It's a very intensive treatment.
I've had some information disclosed to me from the facility. I understand that it will be intense treatment, inpatient. It's like a lockdown facility, I believe.
Okay. Yes, it is. This is what we're going to do. I am going to ask probation to not really hold off, but kind of wait till the end of the week before they send me the documentation that would actually put that into effect. So please, if you all will be in contact with one another, if I don't hear from you all, like there's been a change, then we're going to get you going to treatment, Mr. Rollins, okay? Okay.
Thank you, Your Honor. I appreciate it.
Thank you very much. Good luck to you, sir.
Your Honor.
Monday.
Would it be too much to ask the court if we could bring Mr. Rollins in on Thursdays in person?
We can bring him in on Thursday. Ms. Rob, are you going to be available?
Let me double check. I believe so. I know Thursdays are crazy. I'll be here, Judge.
Okay, so we're going to come in person on Thursday, okay? Thank you so much.
Thank you, guys.
Come on in.
Hey, Mr. Nunez. I'm going to mute you. All right, I see Mr. Mena. Let's go with Mr. Mena's client is Morales, I believe.
Carlos Morales.
Morales?
Downtown, are you there?
Oh, he's downtown.
Yes, sir.
Do you have Morales?
That's not him.
I have Olvera.
Yeah, could you switch to Morales for me, please?
Well, will that mean switching floors downtown?
Yes, ma'am.
Okay, let's take care of Olvera first. But I don't see Mr. Lopez.
Judge, Mr. Lopez is outside. Let me go get him.
Okay. Oh, I got a lot of different movement today. Mr. Edas, good afternoon. Who are you here on?
Yes, Judge, good afternoon. I logged in on Tyler Shropshire.
Okay, we'll be with you shortly. So on Mr. Olvera, we lost downtown, I think. There he is. Thank you. Sorry, downtown. I don't want you to be running around. All right, this is cause number. Does he need an interpreter?
No, Your Honor.
Okay. Cause number 2023-0D08402, State of Texas versus Jonathan A. Olvera Vega. May I have announcements, please?
Ivan Martinez for the state.
Enrique Lopez on behalf of Mr. Olvera.
Mr. Olvera is appearing remotely from the downtown jail. We are set for a probation status hearing. This was a follow-up about some, what I am understanding, and I did see the case summary for today, the basis of the bench warrant is his failure to appear or failure to report, for which Mr. Lopez, you had represented that he was in custody, and we did receive some documentation. I believe it was one date in August. So
Yes, Your Honor.
I struggled to find where the dates were, but I know we discussed, I mean, I think it's close enough, right? Because they talk about in time, I think August 1st, something close to his report date where he was obviously in custody, but it didn't have the actual dates.
Correct.
We met last time. I remember saying that, you know, if all we have is that failure to report, then I'm happy to release him to report on probation and go forward. But I think ultimately what is unlikely is that we don't know that he's getting out, number one. Number two, on the probation summary now, there are some notations there about where he's living and having to move and things of that nature.
Yes, and I can respond to that too, Your
Go
Honor.
ahead.
Oh, yes. Prior to his arrest by ICE agents, Mr. Olvera and his wife had secured a location, and I can give you the location. It's 13356 Greendale Drive, El Paso, Texas, 79928. And looking at it from a perspective, I don't see any schools or anything at that address. However, this was just, I mean, literally within the day or two of him getting picked up from by ICE agents. So in essence, that made the move to the Greendale location kind of moot at this point.
Mm-hmm. Okay, so here's what we're gonna do. I am going to release Mr. Olvera to resume probation. If there are any issues, if he gets out and there are issues with the residents, I know that probation and probably the reporting authorities will be on top of it and will advise the court if we have any issues. I think, if I'm not mistaken, I recall last time, because we were talking about the immigration angle on this, that obviously for the court's purposes, you know, if we have failures to report, I'm issuing bench warrants. Period. So I understand the immigration angle here, but that is something we can address down the road.
Okay.
For my purposes, I'm going to let him go back on probation. I'm going to release him. So Miss Marissa, if you can get me a release to continue on probation and report immediately to his probation officer, we'll see what happens.
Very well, Your Honor.
All righty.
Okay.
Thank you very much.
Thank you, Your Honor.
Have a good day.
You too. Thank you.
All right, downtown. Now we can go to Mr. Mena's client, and while they're doing that, Mr. Mena, we're going to take care of somebody else at the jail annex.
Thank you,
Judge, Judge, my client's wife is here. She's in my office.
Mm-hmm. Okay. Okay. Well, when we get back to you, we'll get started on that bond hearing.
Thank you,
Who's next, Mr. Nunez?
Annex, if we could get John DeCoste next on page 12, Judge, for Mr. Huffman.
Hi, Mr. Huffman. We missed you this morning.
Hi, Judge. I missed you guys too.
Couldn't believe how we were doing it without you there.
I felt left out.
Yeah, so did we. Mr. DeCoste, I did review that. We don't have an evaluation yet, right?
As far as his mental health from us, Judge?
So I think probation was going to do something. Let's get on the record. Is that Mr. DeCoste? Yes. Calling cause number 2023-0D06193, State of Texas versus John Michael DeCoste. May I have announcements, please?
Ivan Martinez for the state.
Rick Huppin for Mr. DeCoste.
Ruiz adopt probation.
I'm sorry, what is your name, sir?
Carlos Ruiz.
Okay. All righty. And so let me go back to my summaries. Mr. DeCoste is appearing remotely from the jail annex. Let's see. Mental health assessment was requested on September 25th. Please note that the CSO is still pending results of the assessment. So,
I got the results of the assessment today in the morning.
Okay.
So he was assessed on the 7th.
Okay.
He does have bipolar.
Uh-huh.
And then he was screened for the mental health caseload and he qualifies. So once he gets out, we're gonna refer him to EHN, to the Tokomi program.
Was he supposed to be screened for mental health when he pled? Or at any time prior?
Yes, Your Honor, but he absconded, so we couldn't like move forward with that part.
So how do we know he doesn't abscond again?
Judge, he was at home. He lives with his mom. It was mainly, Judge, I think a transportation issue, but he definitely knows that he can't do that anymore.
Wasn't there a home visit with no contact?
I did 2 home visits, Your Honor, to the mom's house,
Uh-huh.
and then I did one with the father, no contact.
Yeah.
I think he was back and forth, Judge, but he's going to, once he's released, he's going to be living with mom.
Yeah, but he was supposed to do that last time, right?
I want to say, Judge, the dad is the complaining witness, so that would make sense to me. But I think they have kind of reconciled, and I think they're getting along, Judge. He and Dad.
I mean, how are we going to ensure that he gets to treatment? Because the last time we let him out to get treatment and he went MIA for 6 months.
It'll be difficult, Judge. He has no vehicle. His mom is his only source of transportation, and she has a kind of her own business where she has to, be gone. So I don't know. I would suggest to him a possible bus pass or something of that. That's
Yeah. What type of residential facility? That's part of the recommendation. What are we talking about? Aliviane?
Her TC, Your Honor, but we could get an appointment with Aliviane as well.
That's what I think we need to do at the very least, is to do Aliviane inpatient residential. And so I think, Mr. Reese, we've done this before with you. I mean, we need to get that going. So if there is a process that requires him filling out paperwork or getting interviewed, I'm not going to release him before then. I am not confident that we can get him to a point where he can get to treatment without him absconding again.
Judge, and I just wanted to kind of mention, if I may.
Sure.
The case, the case was from 2023. So he's been on probation for like a year and a half. So he was doing relatively okay for about a year. And the probation office, I guess, had not been able to do the evaluation then. I think it may have helped though. If it was ordered at the time of the plea, maybe it would have changed, the trajectory. But he did do about a year a year and a half of probation, Judge, so he's capable.
So what happened in the year and a half that he was compliant, Mr. Ruiz?
He had attended an assessment, Your Honor, with older, I believe. No treatment was recommended at that time. He was reporting, and then all of a sudden he stopped reporting. Home visit was conducted, no contact at all. And then we issued the bench warrant. He got picked up on it. And that's where we are, Your Honor.
So for a year and a half, he was reporting as instructed. Nobody was monitoring the mental health angle. Is that right?
Correct, Your Honor.
Because there was
Because he
no,
never, well, he was referred to a psychiatrist, but he never got me the contact information. So that's where
Right.
we were.
So why didn't we have a violation notice when he wasn't complying with treatment then?
Because I was working with the client, Your Honor. He was reporting, as mentioned. I was asking him for the information, and each time he will not have it, or like he will forget it.
But I mean, if the core issue, let's assume the core issue is the mental health component, how do we just let that slide for a year and a half?
It was overlooked, Your Honor.
Yeah, that's not gonna cut it. So, I hear you, Mr. Huffman, but at the same time, you know, I'm working with what I'm working with here. And if there is a mental health, a real mental health impediment to him being able to comply, frankly, I don't know how I can rely on, he didn't show up and we just didn't follow up with it because he kept reporting, when really he might have been kind of building up to not be successful because of the mental health angle. So I am,
And I'm not saying that was the whole issue, Judge. He missed in July because he lost his job. He lost service on his phone. He was dealing with some issues, and he missed in July, and I think the warrant came out in August.
okay, so what are you telling me, that it wasn't a mental health thing? He just blew it off?
Well,
I mean,
no, there were issues that I think are fixable, Judge, that are easily fixable.
with what?
Well, he knows now he's been in custody for 35 days. He knows that he needs to report.
No, he didn't know that before? Because he
Well, he
did it for a
did.
year and a half.
He did. He did. Um, even though he had a decent excuse, Judge, I think now he understands that there are no excuses.
But I think you're oversimplifying it because, yeah, okay, now he knows because he's in custody, there's no excuses. But what I'm being told is there is a mental health component here that is not being treated, right?
Honor, if I may also, during the assessment, he's taking medication as of the 7th of this month.
Yeah, which presumably he should have been taking the whole time, right? Maybe, but we don't know because nobody followed up. So to be clear, they're telling me he was reporting for about 9 months. It wasn't a year and a half. Carla, on that reporting 9 to 10 months, was there any period of time where he wasn't reporting? Aside from the months that we have here in July, August? And he didn't do anything else, right? He didn't do BIP. He hasn't paid fees. He hasn't paid court costs. No
Not much.
community service.
Not much.
Everything's outstanding. He was discharged from TAP on 10/30. Was that successfully?
That's because he went to Ozar, Your Honor, and then no treatment was recommended.
Okay.
So Judge,
Anger management.
I don't know if drugs have ever been an issue, Judge. Maybe the probation officer can help me out. Are there any dirty UAs, or we know he didn't qualify for treatment as far as substance abuse treatment, but I don't believe he had any positive UAs either, Judge.
How often was he tested? But I mean, yeah, I didn't know that we were really focused on that part, but how often was he tested? It says last UA was 10/8/24. That's 8 months, maybe more. My math is wrong. Probably about 10 months before he goes MIA. If that was the last test, I'm assuming he should have been tested.
There's a positive back on July 19, 2024, Your Honor, for marijuana.
Mm-hmm.
And then he was sent for his drug test after October, but he did not go.
So why isn't
was-
that in the revo? Yeah, no. Yeah, no, he can do. We can get Aliviane to get over here and see if they can interview him or if they can interview him in the jail, and the court will help do that if he really needs these services. But frankly, it's frustrating for the court when the supervision is not being executed in a way that can, you want to come in here and tell me let him out so we can reassess him, but when we do that, then you don't assess him. And you don't report when they're in violation. And then a year down the road, I get someone in here telling me how probation failed this probationer because they pick up 3 new offenses. Yeah, no. The recommendation is this: the department recommends client be reassessed for any needs he may have to include residential facility, but we're spinning our wheels. All right, Mr. Martinez, do you have any input?
So it's just a matter of whether or not you want to keep him in jail before a facility opens up?
So no, I'm not going to release him until we get him placed somewhere because of his previous non-compliance and frankly, the lax supervision that occurred on his case.
But Judge, I don't think he has any prior drug offenses. I think the only
Positive.
well, okay, the marijuana in July.
Yeah, and then he wasn't tested very often, so I don't know. Maybe he's having a party.
I don't
Could
know.
we maybe test him now, and if he comes out clean?
He's been in jail for 30 days.
Yeah, 35 days. 33.
Yeah, no.
I'm sorry, so how long will it take for the bed to open up at this facility? I mean,
I don't know that we know. If we're talking about Aliviane, I don't know that he's been screened, right?
For Aliviane, no, Your Honor.
Yeah.
But for BHRTC, he has been screened and qualifies.
So the crux of what I was hearing and kind of balancing all the concerns here was mental health. A positive test from July 2024 is a violation, but frankly, I don't think I have enough of a track record to say that this is substance use, right? What we were talking about was mental health. So, utilizing BHRTC on a mental health case, which it sounds to me is like the majority of it is mental health, doesn't sound like the proper utilization of the limited resources that we have, which is why I am suggesting Aliviane. They have more mental health resources, I think, than BHRTC. But we haven't screened him there. And it's the only option I can think of right now that has that residential placement. In other words, inpatient. Yeah. So let's get Aliviane on board.
Yes, Your Honor.
2 weeks, please. If they are available and you need the court's assistance to bring him over so that they can speak with him, please let the court know and we will do that.
Will do, Your Honor.
Thank you. Who's next?
Mr. Smith, I'll be giving you a call soon, okay? This week.
And so it is still 2 TDC or residential placement, Mr. Huffman.
Thank you, Judge.
Thank you. All right. Calling cause numbers 2023-0D06921 and 2023-0D02477, each case styled the state of Texas versus Carlos Morales. May I have announcements, please?
Ivan Martinez for the state.
Judge Daniel Mena for the defendant. The defendant is he should be appearing online.
Yes, and he is, Mr. Morales is appearing from the downtown jail. We were set for bond hearings on these 2 cases. If I'm not mistaken, these are both probation cases. He's at no bond on these 2 cases. In addition to that, he was rearrested on a new possession of a controlled substance, 4 to 200, and I believe his bond there is cash surety, not on my docket. Mr. Mena,
Yes,
may proceed.
yes, Judge. Judge Reyes set that bond at $50,000. when we on the first setting, and I guess the rotation was it was her docket, her case on that particular day, and she understood that it would be transferred over to your case, to your caseload, because the jail magistrates can't touch the bond. Judge, we immediately filed a motion to set bond in the probation. There was no filed motion to revoke his probation. We filed a motion to set bond because he was on deferred. He was placed on deferred adjudication, Judge, in your court in March of 2025. He is currently on federal probation, Judge. He is completing in October, I believe, this October, 2 years, and they're going to discharge him because he had basically no problems, clean UAs. They were testing him three times a month on those issues. On this case, Judge, I understand that his reporting to the state has been appropriate. He hasn't had any dirty UAs. He's employed. He's a citizen. He's employed as a tile setter, Judge. He's got a side business and he works for another company, Mendoza Tile Company. He has no children naturally born. He is married for a period of 5 years. He's raising 4 children, one of which is 19, who is going into the military within the next month. There's a child who is 11 years of age who has she's bipolar, and he's been the one transporting her to school. Because of his incarceration, it's kind of set her back a little bit, but he was the one that was taking her back and forth because his wife, the mother of the child, has travel commitments in her work. So it's been the use of father and mother, stepfather and mother, trying to raise these kids and try to help these people out. The basis of the arrest, Judge, was he was picking up his wife and daughter. It was a 9:30 phone call to go pick him up. He went to pick him up at the bar. Basically, they had to run the tab, so we went to pay it. He gets back to the court, back to his vehicle, and at that particular point, he was charged with the charge with TAC unit, claiming they found a controlled substance under the truck. So it's obviously a very complicated issue. We have multiple witnesses who indicate that the statements in the affidavit by the police officer are not accurate. We would ask, Judge, that you allow him to place a $4,500 bond on each of the cases that you have at this point, and he would make that bond and get employed. He is not a skip risk, Judge. He's been reporting, and we would ask that you allow him to do that. His spouse is here with me now. His son and daughter wanted to log in, and we told them to stay away. It's a lot of people who are very, very interested in trying to assist this family in this case.
Are you asking me to consider the bond on the unindicted case?
Yes, ma'am, I am. Yes, ma'am, because it's going to land. It's in your court because according, I guess the rules say that the presiding.
I understand
the rotating judge has to set it. So she set it at 50 because she knew it was going to land in your court. So she said, just let Judge Ms. Perez take care of this one. I said, whatever you want to do. But that was that one day after the arrest.
Oh, I'm sorry, Mr. Mena, go ahead.
That was one day after the arrest, Judge.
I saw it. It's on YouTube.
Ah, okay.
Yeah. Did you have anything else? Was it its wife? Was wife gonna provide any testimony or?
Yes, Judge. I would. You stand up and raise your right hand.
Ma'am, do you swear or affirm any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can have a seat and put your hand down. Mr. Mena, you may proceed.
Yes, ma'am. You are Crystal Ramirez. You are the spouse of Carlos Morales.
Yes.
Ma'am, and you and he have been married a period of how long?
5 years.
How many children is he helping you raise at this time?
4.
What are their ages?
19, 18, 11, and a 9-year-old.
And the 9-year-old is the one who's the
11-year-old is the one that's
bipolar?
bipolar.
What grade is she in?
6th grade.
And who was taking her back and forth to school and to the therapy
Mr.
center?
Carlos Morales.
Hold on,
Please don't talk over each other. We're taking a record of your testimony, ma'am. Let Mr. Mena finish his question and then you can answer.
Ma'am, who was taking your child to and from the therapy sessions and to school?
Mr. Carlos Morales.
Why were you not taking the child to school?
Because I have to work out of town. I go 2 times a month to travel to Colorado and Missouri because of my work.
So because of that, he was basically helping raise your children at this time. How has this affected the 11-year-old child at this point?
Because he's incarcerated.
How does it affect it? What changes?
It's affecting everyone.
Okay,
How
again,
does it,
I need you to allow Mr. Mena to finish his question
Okay.
before you answer, Ms. Ramirez. Go ahead, Mr. Mena.
what changes have occurred in your 11-year-old that you need to address because Carlos is incarcerated?
Behavior, her bipolar, she's already started going back to counseling.
Okay. Now, do you understand that Carlos's UAs have all been negative?
Yes.
And has he had any problems in reporting?
No.
Has he had any problems with the New Mexico federal court?
No.
Has he had any problems with the El Paso or the state of El Paso, Texas
No.
probation department?
No.
Are you asking this court place a bond in on a $4,500 on each case at this time?
Yes.
Have you been able to secure some funds to try and get him out?
Yes.
Okay. And this evening, this particular evening, he went to go pick you and your daughter up. Is that correct?
Yes.
Judge, I pass this witness at this time.
So, Ms. Ramirez, you were in the truck when he was arrested?
We were coming out of the bar, me and my daughter. Yes, I took her out to a bar and grill, and I know I should have not. She's 18 years old. I was having a couple of drinks. I didn't want to drive because if I get a DWI, I could get fired from my work, or if I have any, or I can't have any charges or nothing, like no DWIs, because if I would get fired.
What do you do?
I'm a sales rep for El Paso area and Colorado and Missouri.
For who? What is
Star Brokerage. I'm a broker. I'm in charge of I'm a marketing in the marketing industry.
All right.
What is it that you sell, ma'am?
Oh.
It's groceries. I'm in charge of all Food Kings here in El Paso, as well as mom and pop stores and Lowe's.
All right. Mr. Martinez or Mr. Mena, if you had anything else.
No, Judge. Again, we have other family members who
Just real fast,
want to stay away.
Okay, so we need to go back to Ms. Ramirez. Mr. Martinez has some questions for her.
Oh, of course.
So, ma'am, you have a 9-year-old with the defendant?
No,
An 11-year-old with the 11-year-old?
11. I've been with him 5 years, sir.
Okay. So
He's practically raised the two young ones, which he got them when they were small.
So the defendant knew that he had two young ones when he was placed on probation back in February of this year.
Yes.
So you know he's on probation, right? For possession of a firearm by a felon and a drug
Yes,
case?
sir.
Okay. And you know that part of his probation is that he not commit any new offenses. Do you know that?
Yes, sir.
And part of his probation is he's not supposed to be out after curfew?
It was 9:40 when I called him for him to go pick us up.
But in answer
So
to
I know it was my mistake. I did wrong, but I wasn't gonna risk me driving over there intoxicated with my 18-year-old daughter. I know I did wrong. I said we're gonna make it. By 10, we should be back home.
Okay. But in answer to the question, you knew he had a curfew.
Yes, I did.
Okay. And you know the police are saying they literally saw him with a baggie of cocaine in his hand. Did you know that?
Yes, I know that.
Okay. Do you feel that it might not be the best for your children to have such a person in your home?
But he's not a bad person.
Okay. No further questions, Your Honor. Pass the witness.
Mr. Mena,
nothing further.
of Ms. Ramirez?
No, did you have questions?
I don't. Do you have any other witnesses or anything?
No, Judge. No, I don't, Judge, at this time. Other than Carlos, who is present, Judge, he's observing all this at this time.
Or did you want to ask him questions or?
I do, Judge, very briefly, if I may.
Mr. Morales, raise your right hand, sir. Do you swear or affirm any testimony you provide will be the truth and the whole truth?
Yes, ma'am, I do.
Thank you very much, Mr. Mena. You may proceed. You can put your hand down.
Mr. Morales, we're not going to get to the basis of the arrest. I'm going to ask you right now, you are currently on federal probation in New Mexico federal court?
Sir, yes, sir, I am.
How much longer do you have till that expires?
I had 9 more months, sir, so I could Terminated successfully.
How many urinalysis per month were you taking under that order?
3, max 4 being out of hand.
Have you ever at any point tested positive at any of those times?
Sir, no, sir, I never did, sir. I've tested negative all the time.
How about the El Paso the El Paso, the 210th District Court's probation officer, the state of Texas? Have you tested positive on any of the occasions when you've taken any tests?
Sir, no, sir, I did not.
Have you reported every month?
Sir, yes, sir.
Have you continued employment at Mendoza's Tile Company?
Sir, yes, sir. And I started my business on the side.
Basically, you're laying tile, so it's kind of tough work.
Sir, yes, sir. I
Tell me about your
tile for Carefree Homes, Saratoga Homes, etc.
Tell me about your obligations, sir, that you understand for the 11-year-old child who is being taken back and forth to school. Have you been taking care of those issues?
Sir, yes, sir. I took her to the doctor, and my daughter was diagnosed with bipolarism and mental health issues. And I need to start driving her to therapy, sir. And I've been raising them ever since they were really young. I've been with my wife for 5 years, and I mean, I don't think it's fair for somebody to say that I'm not eligible to be a parent in that home, you know, when I've been nothing but a good parent. And just due to this little fact that they found something under the car, they're putting me and another person to blame that works for the government, which is not a
Okay, we're not going to talk about the actual incident itself. But my question is there, if there's a commitment, if the judge allows you to be placed on bond, will you report, like you're reporting, subject yourself to your analysis, place yourself on a monitor if necessary to make sure that you report to this judge?
Sir, yes, sir. I will be very eligible to do like that. As soon
That's
as
all
I
the-
get released from county, I'm going to go to the federal building next door because I've been asked from my federal probation.
Okay, sir. That's all the questions I have, Judge, at this time.
No
Mr.
question, Judge.
So I show on the PSR and on the wrap that I have is the federal case the abuse of a child? And is one of those children the ones we're talking about here?
I don't know, Judge.
So
Carlos?
I have on the rap sheet on September 1st, 2022, 3 counts of abuse of a child to New Mexico, transportation or possession of a firearm or destructive device by a felon, Danyana as well. Is that your probation, Mr. Morales?
No, man, those charges were dropped, man. Those charges were dropped. I was based on probation for transporting illegal aliens.
I'm showing use or possession of drug paraphernalia, Danya Anna.
Those were dropped, man.
Yeah, there's no disposition on the rap sheet. Then we start in 2016, possession of marijuana, 2016 evading arrest, guilty, you did 10 days. Assault family violence dismissed in 2019. In 2019, again, violation of protective order 2 times in 1 month. That was here, right? That's what we have. No, that's not what we have.
Yes, man, you sentenced me to 2 years TDC, man, for that.
So I do see you have 2 years TDC. 2019, we get a DWI. There's my violation of protective order again, another possession of marijuana in 2019. So the ag robbery, I thought you went in on the robbery. You were pled down to a robbery and you got 2 TDC there. It was an ag robbery that they pled down here in 2019. You went to TDC. Came out in 2022, discharging a firearm in certain municipalities in 2022. And then unlawful possession of a firearm, 5 years deferred. And that's what we have, right? Somehow you got back on deferred. Then in 2024, we put all those together, and that's how I have my other probation case. And now we have another possession, a 2nd-degree possession. The rap sheet keeps going. Well, there we have your federal 2022 conspiracy to enter, transport, or harbor aliens, smuggling, bringing in and harboring aliens, and you are on supervised release there. All right. Anything else?
No, Your Honor, that's all we have at this time, Judge.
Mr. Martinez, what's your position on the bonds?
I would urge very high bonds in these cases, Your Honor. I don't go around, bringing up people's fitness as parents willy-nilly. The only reason I went there was because the defense went there. To be clear, they're ostensibly they were saying, well, he needs to bond out because he's doing this good job as a parent. That's why I went there. To be clear, I'm not just willy-nilly, bringing his ability to be a parent into question. But that's besides the point, Your Honor. The fact of the matter is, like I said, this defendant, the officer says, I saw him holding a baggie of cocaine with four little baggies of cocaine in his hand while on probation, while out after curfew. So again, he has an extensive criminal history. What I'm thinking here is 10 to do on the revo. Maybe if he accepts responsibility on the revo, we might be able to dismiss the new one. But in light of the fact that we are recommending revocation and TDC time and his extensive criminal history, I would urge the court that it is inclined that these bonds be very, very high in these cases to ensure that he remains in jail.
Mr. Mena, anything else?
Judge, our position, Judge, is the individual has indicated to the court that he has taken urinalysis, he's been clean, he doesn't have any violations of this court's by not reporting or not paying. He's been employed in very hard labor, basically going out and laying tile, which is very, very difficult. He's been he's been a very big assistant to this family in helping the young child continue with whatever therapy issues she needs. He's obviously helped raise a child who's 19 and going into the service. So there's a good structure there at this point, Judge. I believe that he's very, very important as an integral part of this family. This lady has to work and has to leave because of her employment, has to work and leave out of town. So this is just a unit that has to work together. So I think that if we place a high bond on him, Judge, or don't allow him to place a low bond, that it basically makes it much more difficult for this family to continue to help themselves. I would ask that you set those bonds, Judge, in the amount of $4,500 each, with a PR component if necessary to he report as often as you feel is appropriate, Judge. But he is not going to abscond. He's not going anywhere, Judge. He's got a family to take care of, and we'd ask you to allow him to place bond at this time.
Your request on the unindicted case is respectfully denied. As to cause number ending 6921, his bond there is $50,000 cash surety. As to cause number 2477, his bond is $100,000. He was only on probation since February, and we're right back at it, allegedly. So those are the orders on the bonds.
Thank you, Judge. I appreciate it.
Thank you for your time.
Bye-bye.
Who's next?
Judge, on page 12, we have Manuel Garcia. Annex, could we get Garcia, please? Judge, may downtown be excused?
Yes, thank you to downtown. Let me see. Ms. Rodriguez, I thought we reset this basically to get an answer on the 2 TDC. Was that right?
That's my impression, Judge. I don't see my client, but it's my understanding Mr. Garcia wishes to go forward with that.
Okay. Mr. Garcia, good afternoon. Calling cause number 2023-0D03700, State of Texas versus Manuel Garcia. May I have announcements, please?
I have a state.
Karina Rodriguez on behalf of Mr. Manuel Garcia, defense is ready.
For purposes of the record, Mr. Garcia is appearing remotely from the jail annex. At our last hearing, I believe I don't think it was any way unclear that the court was at a revocation. And so I think the state had recommended 4. The court indicated I was comfortable at 2 years TDC. And so if he's going to accept that, Ms. Rodriguez, that I just assume bring him in for an in-person plea of true on Thursday.
Okay.
Yes?
Yes, Your Honor.
Mr. Garcia, I saw you nod your head. What we're going to do is, because I wanted to check in with you and your attorney quickly since you've been in custody. Now that we know that you're going forward with a plea of true, we'll bring you in person on Thursday, okay?
Okay, Your Honor, thank you.
Thank you very much. We'll see you on Thursday.
Thank you.
All right. Thank you, Ms. Rodriguez. Who's next?
Judge, on page 13, we have Samantha Martell.
I show that Mr. Stevens filed a competency motion on Ms. Martell.
That is correct, Your Honor. And I'm covering for him. He is out this week.
Okay, so I think I sent you all an email. We just need to transfer her for evaluation at this time. You know, Ms. Rodriguez, they've been pretty quick about them. So what I mean by quick, it's like not like months and months. It's a matter of weeks. So hopefully we'll get her back and then find out what we're doing. Okay. I think I was looking at, you know, how are we going to set up a plan possibly, but when I saw the competency motion, we'll just get her transferred to get her evaluated. Okay.
Understood. Thank you, Judge.
Thank you very much. Ms. Martell, thank you. We'll come back to you next time. Ms. Rivera, were you here on that one?
Yes, I was, Your Honor.
Thank you for the report. Again, I saw the defense motion after I had reviewed your stuff. So we'll see next time.
Okay, Your Honor. Thank you. May I excuse?
You may. Who's next?
Judge, on page 15, we have Tyler Shropshire for Mr. Huffman.
Mm-hmm.
That one's me.
Oh.
All right, sorry. Are you sure, Ms. Rodriguez? Mr. Huffman looks eager.
Rick, if you want to go ahead and take it. It's unfortunate though, because I
Oh,
already
good.
spoke to him.
I heard my name, but I'm good. Thank you.
Right. Mr. Morales, who are you here on? I didn't see you on the docket now that I think about it.
Mr. Morales was here earlier, Judge.
Oh, okay.
Judge Zavala Hernandez, I thought we had today. At least that's on my calendar. It may not be on yours. Never any guarantee.
I don't want to rely on me. I say no, but let the jefes tell us.
We're on Jessica Hernandez earlier, but that was at 1 o'clock, sir. You were in the 409.
Yes, I've been in the 409th for quite some time now.
He was mentioning someone else. Mr. Morales, I don't show you my 3 o'clock docket, so I'll just throw that out there. You're welcome to stick around.
Okay, Judge. I mean, I don't mind, Judge. I just need a rec from Ivan. I'm not sure if there's a rec, but if that's on the way, then we're good.
Okay, so your client is Jessica Hernandez?
Right.
Oh, okay.
Okay, no, I apologize. If there's not a rec, there'll be a rec by this afternoon.
Okay, sounds good. I'll be on the lookout then for that.
Oh, okay, no, there is a rec. Okay, here we go.
There is one? Okay.
Yes. So reduce it down to a Class A, 2 deferred, or she can do 20 days in jail on the Class A lesser assault.
Or 20 days. Okay, I got it.
Mm-hmm.
Thank you.
Okie doke. All right, Judge. I'll talk with my client and get with Ivan. Okay,
And
thanks, Judge.
Thank you. If we could have Tyler Shropshire. Thank you. Good afternoon, Mr. Shropshire. We're about to call your case, okay? Calling cause number 2024-0D04227, State of Texas versus Tyler Shropshire. May I have announcements, please?
Ivan Martinez for the state.
Karina Rodriguez on behalf of Mr. Tyler Shropshire. Defense is ready.
Mr. Edas, you're on this case?
Yes, Judge. My apologies. Edgar Edas for the probation department.
And for purposes of the record, the defendant is appearing remotely from the jail annex. I did receive a case summary. We are set for probation status. I also reviewed the 1622. There were some mental health details there as well. He's been in custody since the 20th, but appears, I guess, leading up, I think it's the 20th, leading up into that time, Ms. Rodriguez, it seems like he was having basically mental health crisis. He was going to EHN, he was Psych Center and then EHN. So he wasn't here last time. The recommendation, is this from you, Mr. Edas? Yes, is for him to continue on community supervision and screen for the MHI caseload. Mr. Edas, was he not, had we not flagged him for all of that up front? I mean, he's only been on probation since March.
Judge, per his terms and conditions, it only indicates no contact with complaining witness. It doesn't state anything as far as screen for MHI caseload or anything like that.
Okay.
I think one of the issues Mr. Shropshire has is housing. When he was arrested, I guess, or when he was taken to the psychiatric center, I believe he was homeless at that time. And then from there, he ended up going to Aliviane Residential, but for whatever reason, that didn't work out. And then he was picked up on the bench warrant or the KPS for that misdemeanor charge.
Or he was supposed to go to Aliviane?
I believe the people there at the El Paso Psych Center got on placement at Aliviane, and he was there for a short period, but then that didn't work out. And I don't know if they're the ones that called the police on him, and he was arrested.
Miss Rodriguez, how can we, I feel like we might have better outcomes if we have some more resources. What resources might your office be able to help coordinate with probation? So, for example, if he was supposed to go to Aliviane and didn't make it, right? What resources does the public defender's office to help assist get him to where I think he needs to be is probably on some mental health treatment?
It would be the EHN referral, the Takumi. I believe they help with transport. I can probably give you better information. I did file a motion to set bond, and I can have a well-developed safety plan to help address those concerns for the court. And then we can maybe take that route.
Mr. Edas, if you can have an update, say in about 2 weeks, to see if it's possible, if he was due to be placed at Aliviane, to see if that can, if it's not off the table, can be restarted. And then maybe Ms. Rodriguez, your office can coordinate with probation if you all have some resources so that we get him there. I don't want to just, I mean, if there's something that is tailored to his needs and it just requires kind of getting him from A to B,
okay,
let's do that. I'm very open to that. But I don't think we're going to be successful. I mean, I don't want to be a Debbie Downer here, but I don't think we're going to be successful just saying, well, he's got an Aliviane appointment and we're going to let him out and he's going to go. And then, if I'm not mistaken, both probation and maybe public defenders can work on some housing options for him. I mean, we definitely need to put him in the MHI caseload, Mr. Edas. So I don't know if that opens up some more resources for him.
As far as housing goes, I'm not really too sure on that, Judge.
Okay. I don't know where do I hear that like people work on housing? Is that public defender's office, Ms. Rodriguez? No?
It's not, Judge.
Ooh, who helps with that? Okay. Well,
We'll figure it out, Judge.
In the interim, we're looking at inpatient Aliviane. I'm assuming that's what that was, Mr. Edas.
I believe that's what it was. And when they released him from the psych center, he was there for about a week or a week and a half, whatever the case was. And then I guess that didn't work out for him.
How can we get more details on that? What is that?
I will make the effort and I will give him a call. If I have to go down there in person, I will get you all that information, Judge.
Yeah, like if it was he decided he didn't want to participate anymore, was he already being treated? I don't know. So we'll come back in 2 weeks, please. Thank you.
Sounds good. Thank you, Judge.
Thank
That was
you,
my
guys.
last case. May I be excused?
Yes, you too, Mr. Edas, and let you have something else.
Thank you, Judge.
I'll be in touch with you, okay? Okay. To Sherry Lee. I also wonder if he's getting treated in jail. Now we need Justin Smith, Annex.
No, Your Honor.
Thank you. Oh, we're saving the best for last. We didn't see you all morning, Mr. Huffman. You're muted.
I'll make sure I check in next time, Judge.
All right, this is cause numbers 2025-0D06316 and 2025-0D02737. Each case style, the state of Texas versus Justin Smith. May I have announcements, please?
Ivan Martinez for the state.
Rick Huffman for Mr. Smith.
For purposes of the record, Mr. Smith is appearing remotely from the jail annex. We are set for bond hearings in each of these cases. I'm showing 2737 at 100,000. That was a PR revel, I guess, based on the new arrest, and the new arrest and authorized use is at 25,000. Mr. Huffman, you may proceed.
Thank you, Judge. And Your Honor, those bond amounts are way more than Mr. Smith can afford. Currently, Your Honor, he's a self-employed mechanic. He does live here in El Paso. All of his family and friends are here in El Paso. Both cases, Judge, are basically car thefts. He cooperated with law enforcement.
He's a mechanic and he's accused of stealing cars?
That's the allegation, Judge, and he did cooperate, Judge. Both cars were recovered without any damage, so there's no restitution. I don't believe. He has the first case was from March, and this case recently in September. So he's been in custody for about 22 days. As far as priors, Judge, he has a misdemeanor DWI and a state jail possession that was reduced down to a misdemeanor 1 day credit for time served. That's the only criminal history that I am aware of. He has 3 children. Right now, he has full custody, Judge, but I'm not sure what happened to the mom. But he does have custody of these kids. Right now, they're with their mom. I'm sorry, with their grandmother, my client's mother.
Got it.
But as far as the bond, Judge, we're hoping that he can get something that he might be able to afford, and that's not that much, if any. There was one more point that I wanted to make, Judge. While he's been in custody, Judge, he has been very active on the tablet, taking as many classes as he can. I think the probation is a likely outcome, if any. And Your Honor, so he's sitting in jail, and we're asking the court to release him so that he can get back to work and get back to taking care of his kids. And he's just hoping for that opportunity, Judge.
Okay, so he was initially on the theft, and maybe he was at 17.5 PR. I'm showing each count the theft had a $10,000 PR and the possession had a $7,500 PR. So he was at 17.5 PR, and then we get this unauthorized use. He had some traffic tickets. All right, Mr. Martinez.
Well, I'm not quite as upset with this particular with this particular bond case. I'm thinking seems to be some sort of drug problem here, because he had 4 grams of meth on that March drug case. Maybe he's stealing for drug money. I don't know, but I'm thinking maybe we can do some sort of probation rec to run CC with the probation is already on, maybe with safety as a condition. And we can do that sooner rather than later. But I don't think he's a danger to the community. I don't know. I'm not sure what his ties are to ensure. Who is the PO here for this one? Has he been reporting?
He's not on probation. There are 2. He was on PR bond.
Okay. I'm sorry. No, I completely misunderstood.
On 27,
okay,
37,
then
he was
no.
on PR bond.
I'm not opposed to a reasonable bond amount in this case, then, Your Honor.
Well, what do you think reasonable is?
Obviously there needs to be a lot of PR conditions. I'm thinking maybe 10,000 cash surety and the PR component. Okay, well then maybe that's a bit much for him. Maybe 5,000 cash surety with the PR component for each case.
How did he get the 25,000? Let me see.
It's currently 15,000 cash or corporate surety, 10,000 PR. It was set by Judge Rangel.
She knows what she's doing. Let me see. Let me see. On the, let me go. Marissa, you might be able to see this quicker than I will take me to find it. On the PR violation, was it solely the rearrest or was he not reporting to PR?
Let me look at it just because it's coded as committed new offense, but I can check and see if it had any other violations on there.
Let me go in there too. I always open the wrong one.
It's just
new offense.
Actually, no, it's also failure to report. He was supposed to report via phone, and he failed to report in August. His last report was July 2nd.
Okay. All right. Yeah. Committed new offense, unauthorized use. He was booked, and then he was to report once a month via phone, and he last reported in July, so he missed August, and I guess probably September too, because this was dated September 24th. Well, he doesn't report. Why didn't he report, Mr. Huffman?
He was in my office in June. We've had no problems getting a hold of him. We've also had contact with his mom. So I'm not sure about that failing to report in July. Can I ask can Mr. Smith address that?
If you want to ask him.
Mr. Smith, why didn't you report?
I did report. We had a change of PR officer. And I think there was miscommunication because I did leave a voicemail for the supervisor for the PR because they're like, oh, I got a new PR officer. They're not in right now, but go ahead and leave a message. And I even updated my new contacts, my new address, and everything with them.
Let me look at something. Let me see what date is this? Oh, that was in June. All right. Well, unfortunately, yeah. So the anything else? Anyone have anything else? No. So on 6316, I am going to grant the request to reduce bond. It is going to be a $2,500 cash surety bond with, I guess, standard conditions. So we're going to do once a month in person. This is going to be a $2,500 cash surety bond with conditions. Report once a month, subject to testing, no contact with complainants it's the theft, right? Unauthorized use. Commit no new offenses and show up for court, may not change your place of residence and may not leave El Paso County without court permission. Subject to testing, use no illegal drug or alcohol. On cause number ending 2737, that bond is at 100,000, so I am going to reduce it as well. That is going to be a $10,000 cash surety bond with the same conditions as the other case. I guess we need to cross the complainants, Ms. Nieto, so no contact with the complainants on either case are conditions for both cases. I know it's probably might be out of your client's reach, Mr. Huffman, so let me know if you need another hearing.
Thank you, Judge.
All right, thank you.
Did you have, Mr. Smith, did you have something to say?
I have no one out there as a financial backer to get me out at all. My mom's on Social Security, she's on disability, and I'm focused on my son. And I also pay $312 a week in child support. The longer I'm in here, I'm not able to support my son at all. And we'll add complications with his mom. His mom dropped him off and never came back.
I think the judge knows your financial situation.
Mr. Smith, so you know, and I was going to explain this at least about cause number 2737. When you already have an offense, right, and you're out on PR bond, and I understand these are all allegations. I'm not saying you're guilty or anything like that. But when I start having rearrests and, you know, I understand you're disputing the not reporting, that's the best it's going to get right now. Okay, so talk to your attorney and we'll go from there. Thank you, Mr. Huffman.
I'll call you this week, Mr. Smith. Thank you, Judge.
What's the rec, Ivan?
I'm okay with deferred for everything. It's that's what Jose has. Just 5 deferred for everything, theft counseling, drug counseling. So
I'll talk to you. I'll put in a request right now to talk to you, okay? And then we'll see if we can resolve it.
Thank you, Mr. Huffman. Thank you,
Thank you,
Mr.
Judge.
Smith. I think that's everyone for today. Am I right?
Yes, ma'am.
Thank you very much, Annex.
Thank you.
You're good to go. Thank you, Mr. Huffman. We'll see you maybe on Thursday.
That's going to be it for today, ladies and gentlemen. Thank you for watching. Thank you to all the new subscribers to this channel. I do appreciate every single one of you. So that's it for today. Please tune in tomorrow for Judge Ramsey Heath. For now, that's it for the broadcast. I'm ending the broadcast day. So for now, ta-ta and ciao-ciao. You all have a wonderful, wonderful Saturday evening. I'll catch you guys tomorrow.